Our next speaker will be speaking on attendant care, and this is Wanda Rumsam. And Wanda is a rehabilitation service advisor for Allstate Insurance Company. She's got extensive background in social work. She's worked for Allstate for the past 25 years as an accident benefits claims handler, specializing in serious injuries and CAT claims. She very, very much hopes that she will be retired before the CAT definition changes. Okay? She's going to be speaking specifically on how we're going to be qualifying family members to provide compensable attendant care, which is a huge problem right now, how to prove that economic loss that's necessary, and she'll be providing us with examples of what is considered to be an economic loss. So please welcome Wanda.
Good morning. I just spent a couple hours on the highway, so I'm out of breath. Drink Carrie's coffee. Next time, no sugar, please. I've worked with Carrie for quite a few years as a case manager, so I feel quite confident her coffee's okay. When I was contacted by Howie Saxon Henry and requested to speak on this subject today, I said to the person, "Are you setting me up? Really? You want me to speak on a sensitive subject like attendant care and economic loss? Really? To a group of treatment providers, lawyers? Do I need to wear a vest, bulletproof?" Well, I have one on. That's what took me the time to get here today. So it really is a sensitive topic. It's been hard for the treatment providers, the family, plaintiff lawyers, and actually us adjusters also. We've all been struggling to try to deal with this change in the SABs. We're now probably, what, a year and a half post, to my knowledge. There's no cases yet determined to guide us on what is economic loss. Jamie, there's no cases, no. So we're trying to do the best we can. I should tell the audience today, I handle only catastrophic or very serious injuries likely to be catastrophic. Today I'm speaking what I do only on behalf of myself. I can't speak for the insurance industry, nor would I want to. It's vast and it's different. Nor can I even speak on behalf of even other adjusters within my company, because handling these claims, I try to handle them the best I can. Well, actually, I'm going to take a step back. When the change in SABs come out, I went to the management of my company, Markham, different office than me, and said, how do we address that? I only handle catastrophic claims. These are the people that need attendant care. How are we going to deal with this topic? And I was told that to deal with it, as I always do, to deal with according to SABs. That's clear, right? To everyone? This is my booklet. I've received no training booklets, no memos, no pamphlets. This is how I handle my claims, SABs. Maybe clear to you, but it's still not to me. So, and I was told also, because I try to relay, my clients are the ones with the very serious injuries. They need the care. There's no question about that. I feel SABs, the intent was not trying to penalize those clients and cause all this confusion in the industry that we've been trying to deal with. I don't think it was for the catastrophic or seriously injured clients. So I was told to handle the claims according to SABs and do the best I can for my clients, so that's what I've been trying to do. And I'll try to give you a few examples how I've been trying to do that. I was lucky enough. I was the first adjuster within my company. We're Allstate, Pembridge, and Pathco, so I wear 3 hats, 3 business cards, and a lot of email. Too much, actually. I was lucky. I got the first claim under the new definition of economic loss. Lucky me, right?
2 types of luck. Good, bad.
I usually get the bad luck, Jamie. That's why I want to retire shortly. So what I did, and actually it was a difficult claim, was a lady hit as a pedestrian, needed 24-hour attendant care. Well, I'm going to go back to care. There's different thresholds for a person to qualify for care, and most of them are very clear now because we've lived with accident benefits since 1990, and we've gone through many different legislation. Actually, too many. I can't keep them all straight. I have like SABs lined up like this for all the changes. But when this claim came in, this lady was hit as a pedestrian, required 24-hour care without question.
Sorry to interrupt you, but I'm not sure that people can hear you well enough. You have to maybe pull the mic closer to you.
Can you hear me?
Okay, so just wave at us from the back there if you're having trouble hearing, and we'll fix it, okay? Thank you.
Oh, that would be the first time. I'm usually told in the office I'm far too loud. And this lady, so met the first threshold. She needed 24-hour care without question. The Form 1 under this legislation determines, in my opinion, the care that is required. So then I had to deal with the third issue. The person providing the care, do they have an economic loss? Well, this is a struggle, and I've been struggling with it for the last year and a half. So in this case, and I think this is key, every case I've had since then, the first thing I do is pick up the phone and call the lawyer. And we've been working together to define economic loss and ensure that there is some type of economic loss and these clients are getting the care. So in this case, it was a lady of a different nationality background. So they weren't going to have outsiders come in and provide the care. It had to be within their community and their culture. So what I received to support it was a lady within their community who opened a business. Actually, I'm going to call it Rumsam Assistance. It was a different name, but similar. And this lady, I actually Googled it. It was a registered business. But my client was their first client also. And this family was actually paying this person to provide the care. So I paid the attendant care in accordance with the Form 1. I'm understanding, and actually it's the first time it's this week, not all insurers interpret economic loss once the threshold is satisfied is in accordance with the Form 1. So that was a surprise to me, because when I read this, the SABs, which is very clear, I'm sure you'll all agree, I feel they have to meet the criteria, but once it is met, it is in accordance with the Form 1. And I think if we look at all the past legislation, which started like 1990 OMPP, there was no Form 1, and I mean, there's many cases how attendant care was defined and funded. Then we went into 164 when the Form 1 came into place, and that hasn't changed, in my opinion, under Bill 59 or the change of September. So I feel we still owe, in accordance with the Form 1, not what the individual's actual economic loss is, but that's my opinion. We've tried to be very creative on a lot of these cases. I've had another, I think this is one of the more complicated. I've had another case where the individual providing attendant care is a mom, stayed home, no job, no, I guess, what is economic loss? The first thing I did when the definition came out was Google it, trying to get a definition. And I guess it's like everything in SABs, it's how one interprets it. To me, economic loss is not just a person's wage loss. It can be met in many different incidents. I have a case where I've accepted it personally, where it was a stay-home mom. She didn't have a job, so she wasn't losing wages, but because she had to look after this child who needed 24-hour care, she wasn't able to care for and provide the services and care for her family she normally did. She had, babysitters come in and help care for the other children. I said to the lawyer, I feel if she can't even grocery shop, there's Grocery Gateway. That's an extraordinary incurred expense she didn't have before that she now has because she has to provide this care to her child. So to me, that is an economic loss. So I guess it's how we're going to address economic loss? Are we going to look at it? If you look at it at a quick glance in SABs, some insurers may feel it has to be a wage loss, and that's, I feel, is a very narrow interpretation of economic loss. To me, with the cases I handle, I feel we have to look at a much broader interpretation of economic loss. And the thing I said when this first came out, I certainly would not be the first adjuster on the stand to try to quantify why I'm not paying for the care provided to an individual that has a catastrophic loss. I'm going to leave that up to another company.
What are you going to be for?
You may be on the other end, or individuals like you. And I've handled many cases. I had another case, here's another example, where I spoke to the lawyer and I said, so what are you going to give me to substantiate the care being provided to this individual? And she said, well, Wanda, I'm really not sure what we're going to do, because his wife, who 68, 69-year-old lady, is providing the attendant care, and his daughter is coming in, but she's self-employed, freelance writer, and does all this volunteer work, and so she has no wage loss, so I'm not sure how we're going to substantiate to you. Ooh, self-employed. Ooh, I think anyone self-employed can substantiate an economic loss, in my opinion, because I don't take economic loss actually what your wage loss is. I feel it also can be interpreted what your opportunity. Any self-employed person can have a loss of opportunity to earn more. I don't think the SABS addresses economic loss as it does a person where before the accident, if they had a job offer to be employed, earn an income. The SABS is very clear. You had to have it before the accident, had to be evidenced in writing. So there's very concrete criteria you have to meet. Economic loss is gray. It's not clear, it's not concrete, and I feel it's very broad. My experience as adjuster, arbitrators, judges, especially if it's an individual with a significant injury, catastrophic, they're not gonna try the case to the advantage of an insurer. They're going to give the catastrophically injured person a very broad interpretation, and they're going to get the care. Like, the cases haven't been tried yet because fiscal is so backlogged, maybe another year or two, you think? Maybe 3. We'll get a case, but when it does come, it's not going to be a stringent interpretation, in my opinion. So I feel as insurers, yeah, we have to have something to quantify our file, because we answer, unfortunately, not to only ourselves. There's many outside auditors. Actually, fiscal comes in and audits us. Yeah, interesting, isn't it? They audit us to ensure we're complying with SABs. But yet, many of their decisions aren't in compliance with SABs, but they audit us. And we can be fined as insurers if we're not, in their opinion, in compliance with their timelines, like the procedures of SABs. However, that being said, I still feel when the cases are heard, it's going to be a very broad interpretation, and they're going to accept pretty well anything I feel plaintiff lawyers are going to provide to substantiate the attendant care. So I think one of the keys in addressing this, and I've been very successful in this in all my cases, because I've had several catastrophic cases in the last year and a half. The first thing I do is contact the plaintiff's lawyer, say, okay, how are we going to deal with economic loss? We brainstorm together, we create or agree what is acceptable will be provided. They send it to me. That documents my file, supports my file, which I need. We have to have something to substantiate what we're doing, so help us. And also, if there's any plaintiff lawyer lawyers out there, take our calls and speak to us and help us do what we need to do. There's been, like I said, every case I have, I'm paying attendant care. There's not a case in my caseload to date that I'm not. So there's been many things we've accepted as economic loss. So I'm not sure if there's anything else. I'm sure you have a few questions. But
There'll be lots of questions, because you're not the norm.
and I have my bulletproof vest on.